a second. Okay. Before the court is file 23110 FC. It's People of the State of Michigan versus Shanda Vander. Are you Shanda Vander?
Yes.
All right, Mr. Vander, Miss Vander, can you hear and understand me okay?
Yes, I can.
All right. Ms. Vander, we had confirmed through your counsel that you wish to appear at this hearing via Zoom today. Is that still your desire?
For this hearing.
For this hearing. Okay. All right. Mr. Ambrose is here on behalf of the defendant, Ms. Vander Ark. Mr. Roberts, as well as Ms. Bloomquist, is here on behalf of the people of the State of Michigan. State and time scheduled for a hearing on plaintiff's motion for a new trial or evidentiary hearing. Or excuse me, defendant appellant's motion for a new trial or evidentiary hearing. The court has read the motion, the attached brief, as well as the plaintiff's response and brief in opposition to that evidentiary hearing, including the attachments. Was there anything else that was submitted, either Mr. Ambrose or Ms. Bloomquist, that I don't have at this time?
I have not submitted anything.
Okay, Ms. Bloomquist?
No, Your Honor.
Okay, Mr. Ambrose, at this point in time, you want to just make some argument? You can call witnesses. I'll leave it to you at this point.
The testimony is going to be taken. I would prefer that I have my client with me in person. That's our preference in this type of setting. Typically, on a motion like this, if the court grants any type of evidentiary hearing, that would be great, and then we could have Ms. Vander Ark in person with us.
Okay.
But other than that, I did write a pretty detailed brief in this case, raising two primary issues. One is whether or not Ms. Vander Ark was competent after giving her first day of testimony. She had a medical issue. She was in some sort of distress. Coming back the next day, it seemed pretty, from the transcript at least, that she had undergone a significant downturn in her mental health. That it was described by her trial counsel that she was not competent to go forward. I think there was about a 2-hour delay. There was some sort of discussion with Ms. Vander Ark. There was a report that she may have wanted to hurt herself. All of these factors are pretty consistent with the case that I cited, seminal cases, Droke versus Missouri. And if you look at that case and Ms. Vander Ark's situation, they pretty much fall in line. So, if the bottom line is, well, was there a bona fide doubt as to her competence? And if there was, then the way to go about things is suspend the trial, have her checked out, and then if there is no longer an issue there, then proceed with the trial. And that's consistent with what Droke says, but it wasn't done in this case. And if there is additional testimony taken on this issue alone, like I said, I would like to have Ms. Vander Ark here for that. The second issue, Your Honor, is ineffective assistance of counsel. I laid out a number of areas that I feel that there were some missteps in that Ms. Vander Ark was not provided her Sixth Amendment right to the effective assistance of counsel. And we do start off again with the competency issue of not requesting her to be evaluated. And so that was one issue. Another issue that we raised is Ms. Vander Ark testified at the time of trial. She's always remained consistent about her innocence. And trial counsel, during his closing argument, made a statement to the jury that she was guilty of manslaughter. Well, my client never consented to that type of argument, never consented to a lesser included offense. So that's a second issue that we have raised, and is ineffective assistance of counsel. I've made a number of other areas that we felt that trial counsel was ineffective, and one was on the death certificate. The first thing that is noted is dehydration. And in this case, there was many allegations about Ms. Vander restricting food to her son. But there was never any type of allegation about restrictions of water or liquids or fluids. And if you do any type of research in this area, you know, a person knows that they will die within days if they don't have any type of water. But a person can literally last weeks, sometimes months without food. And so with dehydration as being the first statement in the death certificate, I think it was important to highlight that as a trial counsel, because that is what's the first statement. And I think in my reading of the transcript, there was only one question about that by trial counsel. I think the main focus in the case could have been or should have been that the real cause of death was dehydration, because there was never any type of restriction on water.
As that report indicates, the defendant had a, quote, sophisticated understanding of the roles of the various court participants, her defense options and possible outcomes, and clearly voiced her willingness to engage and rationally assist her attorney in this matter. And then the clinician went on to say, I did not observe any behavior indicative of an intellectual disability or other cognitive, physical, or psychiatric issues that would impede her adjudicative competencies. Your Honor, the court can absolutely consider all of that in making this determination as it relates to the defendant's competency. And I think that the record supports that this court made the proper determination that she had not overcome the presumption that she's competent, and in fact, not holding a hearing was the right decision on this matter. Now, to succeed on a motion for new trial, the defendant would have to show that there's a basis for appellate relief. And looking at your decision and this court's decision, there is not a basis for appellate relief on this issue. Now, I do know, I am prepared today to take additional testimony should the court require it on this specific issue in the form of individuals who saw her during this claimed incompetency, who would be here to testify as to their observations of her outside of what the court itself observed in making this decision. And so I'd be prepared to do that today as it relates to issue 1. But ultimately, Your Honor, there is no basis for a new trial as it relates to her feigned or malingering incompetency that's been presented today. Turning to issue 2, as the court's well aware, the burden's on the defendant to prove that she was denied the effective assistance of counsel. And that burden's twofold. First, she has to show that there was deficient performance, and she has to show prejudice. And I'm going to be a little bit out of order here, Your Honor, because she has to prove both. She has to prove both prongs. And in light of the overwhelming evidence that was presented about this defendant's culpability and her guilt in what happened with her son, it's my position that she can never establish that any of these claimed instances of deficient performance, which I don't agree are deficient performance, but for the sake of argument, if we were to assume they were, she could never overcome that second necessary requirement of showing that any of Mr. Johnson's actions prejudiced her in light of the overwhelming evidence supporting her guilt. And I do have all of my responses to the prong 1 as it relates to those, as it relates to the individual claims of deficient performance. But Your Honor, I don't believe that the defendant can ever meet that Strickland standard and show that she was denied the effective assistance of counsel. I would note, however, like I said, for issue 1, I do have Mr. Johnson here, who, as well as another individual from his office, who would be willing and able to testify if the court were to order a Ginther hearing. And I'd be happy to answer any questions the court might have.
All right, no, I don't have any questions at this time.
Thank you.
Mr. Ambrose, I'll give you a chance to briefly respond if you wish to.
I've already said, thank you.
Okay, all right. All right, well, as indicated by both attorneys, the court always starts with a presumption, that's under MCL 330.2020, that a defendant of criminal charge is presumed to be competent to stand trial. That statute indicates he shall be determined incompetent to stand trial only if he is incapable because of his mental condition of understanding the nature and object of the proceedings against him, of assisting in his defense in a rational manner. There's case law that also indicates that, quote, a criminal defendant's mental condition at the time of trial must be such as to assure that he understands the charges against him or her and can knowingly assist in his defense. The court, obviously the parties know under court rule, either the parties or the court sua sponte has the ability to address the defendant's competency at any point in time in the trial proceedings. The trial court, specifically me, has the duty to raise the issue of competency where facts are brought to the court's attention which raise a bona fide doubt, that's in quotes, as the defendant's competence. That's specifically a quote from People v. Harris, 185 Mich. App 100. That is actually cited in the Camerad case. Mr. Ambrose cites the two primary cases. It's People v. Camerad, 307 Mich. App 98, and the federal case of Droke v. Missouri, 420 U.S. 162, a Supreme Court case. So essentially the question for the court is, did the court ultimately, under the section labeled competency to stand trial opinion, the examiner indicates in quotes, I did not observe any behavior indicative of intellectual disability or other cognitive, psychological, psychiatric issues that would impede or